Hello, folks. I'm attorney Rp Foley, and I got I got some time while I'm driving. So I wanted to share everything that you need to know from the time of arrest all the way through a plea or a trial. Hopefully, I'm not long-winded. Hopefully, these details help into our family member. That is my only purpose. All right. So, police are on scene. You are being arrested. I don't know why you're being arrested, but you are being arrested. What should you do? What should you not do? You should not ask questions. You should not talk to the police. You should not be rude to the police. You should not fight with the police. You should not run, right? What should you do? You should ask the police if you can make a phone call to a loved one to let them know that you've been arrested. If they say no, that's okay. Why is that okay? Because eventually, within 24 hours, you're going to see a judge. And a judge is going to tell you what you've been charged with. And even if you do not have an attorney, there will be a public defender at that hearing, and that public defender will act as your attorney on that day and help you get a bond. So asking questions of, why am I being charged with this? Or why is this happening? Or what's happening next? You don't need to do that. And why do I say that? You don't need to do a lot of things in life, but you do them. Well, the more you talk, the more likely it is the things that you are saying, the things that you are asking will be used against you in court. And you've heard that a million times, right? Loose lips sink ships. Quit self-snitching. The issue is you're going to see a judge. So if you are allowed a phone call, or if you have a friend or a family member that's nearby, hey, John, just let them know that you're going to the jail. Maybe the police officer, you know what county you're in. Hey, I'm being arrested in Broward County. Hey, I'm being arrested in Palm Beach County. Hey, I'm being arrested in Orange County. Hey, I'm being arrested in Volusia County. That's all anyone really needs to know, right? Why? Because the first thing that your friends or family members are going to do is they are going to call a bondsman. Wait, not an attorney? This isn't a sales ad? No. The attorneys can't help you right now. The bondsman can help you. The bondsman can check in the system and see what you've been arrested for. The bondsman can check what bond has been set, and you can pay a bondsman 10% to get out. So if you have a $5,000 bond, you pay him $500 and he or she gets you out. Or if it's a $5,000 bond and you want to pay cash, for your loved one, you can do that. Now, do I recommend that? No. I recommend you use the bondsman because you only pay 10% and that's it. When you pay to the jail, they always figure out a way to charge you and to take money out of that. So if you pay a $500 bond, it's just rare that you get anything back. So I would always use a bondsman. Now you get to the jail. Let's just use Broward County Jail or gun club as an example. You're going to arrive there. While you're driving in the car, do not talk to the police officer. If he asks you a question, if it's like, are your cuffs too tight? You can answer that, right? Are you okay? You're comfortable? Okay, you can answer that. But you really want to limit your conversation without being rude or discourteous, right? He's doing a job. He thinks you're guilty of something. He arrests you. The time for debate is not in the cop car. If you are handcuffed and your buddy's handcuffed or your girlfriend's handcuffed and you're both in the car, now is not a time to have a conversation because all police cars are recorded inside. There's cameras. They see what you're doing. If you're charged with a DUI and you're drooling on yourself, they're going to see it. So all you can do is sit there and be quiet. Again, you're going to see a judge within 24 hours and all your questions are going to be answered once you're released, right? Or even in the jail, people are going to, the deputy's going to come up and say, hey, you're charged, you have an arraignment, and they're going to be waking you up at the crack of dawn because you're going to be seeing a judge. So relax, don't ask a bunch of questions. Now, what does your family do after they contact the bondsman? I get it, Pop. Everybody's driving crazy. So what does your family do? After they call the bondsman, they should consult with a minimum of 3 attorneys. That's right. I'm not just selling myself here, folks. You have to find the attorney that you think is best. How do you do that? You read some Google reviews, you check the Florida Bar website, and you contact the attorney. You see if you can do a phone consult or a Zoom, and you talk to them. Now, not everybody gives a free consultation. I do a 5 to 10 minute consultation, usually 5 minutes, and I quote a price because I get 100 calls a day. The people who are serious say, hey, I want to do a more in-depth consultation. What can I do? And I charge $150 and up to an hour, and I answer all their questions, and I walk them through the process, and I look at the police report. While we're talking about police reports, the family, get out. You should not go to the police station asking for a police report. Bad, right? You're just going to cause problems for yourself. Everything is online. The clerk of court in every county in I think Miami, I always struggle to get it, is a probable cause affidavit. You can pull it up online. Or you can go to the clerk of court and get a copy. Well, they say it's not available. It's always available. You know why it's available? Because the judge has to read the probable cause affidavit within 24 hours to set a bond or to deny a bond. So it's in the system. Sometimes it may take 48 hours, right, to get into the clerk's website. If it's not in the clerk's website, and let's say your loved one gets arrested on a Thursday, well, you can drive over to the clerk of court, not the police station, the clerk of court for that county, and pay for a copy. It's $1 to $4. No police stations. Okay. Now, for the people who are sitting in jail going, what am I going to do? What am I going to do? What am I going to do? Don't get advice from your cellmate or cellmates. Everyone's got an opinion. Everybody in custody is innocent. Everybody in custody knows somebody who's got their brother off of a murder case, and there was 50 witnesses. The judge himself was a witness, and they have a friend who's a lawyer who's going to miraculously win every single case. Guess what, folks? There's no attorney that's won every single case. None. All right? I have a high percentage of victories, and I have lost cases. Okay? And I've lost cases that I don't think I should have lost. Right? You can't win everything, but you need an attorney that's passionate. But what is your focal point? Not to sit and talk to your cellmates about your case. You're not there. It's not a dorm room. It's not a social experiment. Pop, you okay?
Yeah.
All right. You all right?
Yeah.
All right. We're gonna call it coughing video. You all right? Drink some water, Pop. I got my father-in-law. Pop, you okay? Do I got to pull over and do the Heimlich?
Okay.
You good?
Yeah.
Okay. All right. I'm not a doctor, Pop. If you get arrested, I can help you. I can help win your case. But if you start having, if you cough to death, I'm gonna have to pull over and call EMS.
Okay.
All right. Okay. All right. So you all right? You good? Seriously?
Yeah.
Okay. So do not talk to people while you're in the jail. I'm not saying be rude and discourteous and get yourself into a fight. I'm just saying let's not talk about, our potentially what the alleged crimes that we're in there for. All right. Receptionist will get that. I'm talking. All right. So you're going to see a judge within 24 hours. Now, you may or may not have an attorney. I get this call all the time. I have someone, it's Saturday, it's Sunday, it's Monday, Tuesday, Wednesday. I need someone in the courtroom now. Guess what, folks? On most crimes, there's what's called a scheduled bond. That means the judge goes, oh, you're charged with grand theft? Okay, it's $1,000 bond. You pay $100 to a bondsman. That's it. Do you need an attorney for that? No, because the judge reads off a pre-completed list and it says petty theft, $100, grand theft, $1,000, DUI, $1,000, domestic violence, $2,500. There's a pre-list. There's no argument. There's no argument for the attorney. Now, is that every case? No. If you're charged with a life felony, guess what? There's no bond. You're going to be held without bond, and your family better hire an attorney. If you're charged with something like drug trafficking, right? It's a case that I have a lot of those. And can be drastically reduced by the use of an attorney. But is your simple violence case going to be reduced? Is your simple petty theft, grand theft, possession of cocaine, possession of marijuana, drug paraphernalia, driving while license suspended, is that going to be drastically reduced by an attorney coming into court for, it takes them longer to get dressed, longer to drive there, longer to wait for the judge to be called up, then it will be that they'll actually talk for you. A bond hearing generally, first appearance, is usually a minute. A minute. Is it worth $2,000, $4,000, $5,000 for that? Unless it's a very serious case, it's not worth it. And I tell people, it's not worth it. The public defender will help you while you're there. A bond will be set, or pretrial release, or SOR will be set, which means you're like on an ankle monitor, or you have to call in, and the hearing's over, and you'll be released later in the day. If it's a very serious case, then your bond's going to be denied, or it's going to be a ridiculous amount. And when you hire an established attorney, they're going to file a motion to reduce bond, or they're going to ask for an Arthur hearing if it's a life felony, and they're going. So, do you need an attorney to rush on any day of the week and pay? The average in Palm Beach, I'll just tell you, is like $4,000, $4 to $5,000 just for an attorney to show up at that hearing. I'm telling you, it's not worth it. And I'm an attorney. And guess what? People call me all the time and go, yeah, I know. You don't need me. You don't need me for that. I gotta get a camera that shoots out of the car so you can see what I'm doing as I'm driving. I just have a dash cam, so my hands are on the wheel, but people are just all over the road. Anyway, so if the public defender handles your first appearance, that's what it's called, first appearance. They read the charges. The judge finds that there's probable cause, which is the lowest standard, right? Basically, someone said that you did something, and that's it. That's probable cause. And then they set a bond. It's either a scheduled bond or the judge has some discretion. If the judge has some discretion and it's some serious case, maybe you hire an attorney for that. Those are the cases that I'll go in at first appearance for. But your standard misdemeanors, your third-degree felonies, even your second-degree felonies, like you really don't need anybody. When you have first-degree felonies, then bond can be high, and you're going to get the best bang for the buck by hiring an attorney, even if an attorney is charging you a few $1,000s to get over there on a Saturday morning or a Sunday morning. It's going to be worth it because you're going to save that money and not have to pay to get out. It also may help you to not be on house arrest or to be on SOR. I hate house arrest. I hate SOR. I think it's rarely necessary, but it is often argued by the state attorney's office. Judge, we're asking for SOR. We're asking for an ankle monitor, house arrest. Oh, stop. someone stole something from Macy's and they want to put you on an ankle monitor for the next 6 months of your life. That's ridiculous. So that's what an attorney would argue. And again, even if it's put on, you can file a motion to get it removed. So don't panic. All right. So first appearance, you probably don't have an attorney. You exit the jail. Your loved one pays 10% to a bondsman. Now you can take the time, you can talk to those 3 attorneys, you can meet with them, you can Zoom with them, you can do an in-depth consultation, and you can get a feel for them. Are they taking the time to talk to you? Are they answering your questions? Do they talk above you? Do they talk down to you? How do they treat you as a person, right? Everyone's got a great story and, I do all this. One of the biggest questions I get all the time is, have you done this before? Yes, I've done this before. Have I done a case exactly like yours? No, because there's no case exactly like yours. Each case is different. Have I handled burglary cases? Yes. Have I handled self-defense cases? Yes. The only type of case that I have not handled is a murder case. I've handled stabbings, I've handled every kind of domestic violence. I've handled arson. But guess what? That helps you. You know what's helped me the most in my practice to help people in their criminal cases? DUIs. You know why? Because everybody thinks that DUI is the simplest thing, and it's not. You learn about CAD reports. You learn about TAR reports. You learn about body camera. You learn about jail videos. You learn about radio frequencies. You learn about accident reconstruction, right? DUI has so many different areas that it helps. When I did a shooting case, I needed to know things. My DUI practice helped me dramatically. So it's not whether or not someone's done it. Granted, does it help if if you've done something before? If you are a criminal defense attorney and you don't dabble in 15 different areas, if you look at a website, folks, and the attorney says, yeah, we do DUI defense, we do personal injury, we do family law, we do landlord-tenant, we do bankruptcy. You know what he or she is good at? Probably nothing. Try to find someone that focuses and narrows their practice areas down, right? That's just my opinion. I do 2 areas of law, criminal and personal injury. That's it. Do I know about other things? Of course. Am I going to take someone's money to help them with them? Nope. Refer them to someone that does that primarily. That's my recommendation for you. All right. So you talk to the attorney, you read reviews, you check the bar website. Nowadays, right, you have to check if the attorney's been arrested. So as crazy as that sounds, Google Rp Foley arrest, right? I've not been arrested, but I'm just giving you an example. Whatever attorney you, because I can't tell you how many times I've seen an attorney that's been arrested or an attorney that's been disbarred or is back or has had problems with the bar, and people hire them. And I'm going, my goodness, does anyone not Google? Type in negative reviews. See what clients are saying. Also pay attention to what kind of cases. There's attorneys that have 3,000 reviews, but all the reviews are about traffic tickets. If you have a DUI manslaughter case, do you really want the traffic ticket guy representing you? I mean, if you have a felony charge, do you want the guy that got the red light ticket dismissed because the camera wasn't functional? Like, is that like, you got to think a little bit, right? You have to think about what kind of cases are people handling? Are they handling felonies? Are they handling misdemeanors? Are they handling 3rd degree, 2nd degree, 1st degree? And that's a great question to ask attorneys. What primary cases do you handle? Like me, I handle misdemeanors through 1st degree felonies daily, weekly, throughout the year. That's a good question to ask your attorney. But again, it's all about the connection that you have. If the guy's like, 10 grand, have a great day, thanks, and doesn't answer any of your questions, do you think all of a sudden he or she's going to be more approachable later on? Probably not. If someone, yeah, that's the bottom line. If someone is struggling or you're struggling to communicate with them, that's a problem. You should be able to sit down in a lawyer's office or on Zoom or on a phone on an in-depth consultation without interruption and ask questions and say, listen, these are the facts of my case. Tell me what options you see from the beginning. What's so hard about that? So I may say on a felony 3rd degree, diversion may be an option. A plea may be an option. A trial may be an option. A motion to suppress may be an option. I had a case recently where a woman had another attorney and it was an overdose. Well, the Florida statute, they were asking for prison time because she had a prior criminal history. I looked at the case and I said, and she told me, she said, oh, I watched one of your videos on overdose. I filed, I drafted a memorandum of law, which, I don't know, took me a little bit of time. I put the section of the law and I just put basic facts, and the prosecutor's like, yeah, I disagree. And then 10 minutes later, he goes, you know what, disregard that. I just actually read your memorandum, Mr. Foley, and you're right. 5 minutes after that, I got the case dismissed. She was facing incarceration, and the prior attorneys that had talked to her said, yeah, sorry, you're just looking at, incarceration, jail or prison. And I think they were asking for 364 days in jail, followed by 2 years of probation. Dismissed. Now, I'm not trying to tell you a war story, but what do you do as an attorney? These are questions that you ask. Have you had drug cases? Of course I've had drug cases, just maybe not one exactly like yours. These are some of the things that I've done. These are options that other clients have had. Again, if you're spending an hour on a paid consultation, in an hour, I should be able to give you some feedback if I have a probable cause affidavit. That means the arrest report. Plus, I have the additional officer saying, I have your input, or maybe I have a friend or family member's input who was there. So interviewing your attorney and choosing the right attorney, it is difficult, but you gotta find someone that you can talk to. If they're highfalutin and too busy to talk, and you feel overly intimidated, it's probably not the person for you. That's just the truth. All right. So you hire the attorney, and I've done the 10 things that you should be asking your attorney. So I'm not going to be redundant, but beginning of the process, you have an arraignment. At an arraignment, think of the movie My Cousin Vinny. You are going to either plead guilty or not guilty. Your attorney does that for you in the pleadings. If the charge has been changed, let's just hypothetically, let's say that you are charged with a DUI, or let's say a grand theft, 3rd degree. And they increase the charge to a grand theft 2nd degree, and they add additional charges. You will then have an arraignment and bond status. That means that your attorney is going to have to be at court. You're going to have to be at court with them, and your bondsman may need to be in court because they need to provide an affidavit to stay on bond if the bond has either increased or decreases or the words have changed. So if you see arraignment and bond status, you and your attorney must be present. If you're not there, then there's a capias and you get picked up, and you don't want to do that. So your attorney, if he sees an arraignment and bond status, means that some work needs to be done. Conversations need to occur between the prosecutor and your attorney prior to going to that hearing, because otherwise you may just be taken into custody, and you don't want that to happen. All right. So you have arraignment, you either go or you don't go. Most of the time you don't go, because most of the time it's just an arraignment. We plead not guilty for you. We request a jury trial. We request discovery. That's all the information that there is against you. We take all of that information, and what do we do with it? We hide it. No, we give it to our clients. And I say, hey, Bob, here's all the discovery that I've received so far from the state. Bob, I need to also get a video. Bob, I also need to get body camera. Bob, I also need to do some other stuff. I need some money. I need to go grab those things from the police station. and I do a bunch of requests through records to the police station. Some jurisdictions will give this stuff to me. A lot of them do not, and I have to acquire it through the police department or the arresting agencies. So I give my client that information. Now, that first arraignment, it gets continued, right? That court date changes. It usually will get your second court date within 30 days of an arraignment. That court date, whether it's called a calendar call or a status or a docket call or a calendar call, whatever it's called, every courthouse, every jurisdiction in Florida seems to call it something different. You have to find out from your attorney, what is this first court hearing? What is the purpose of it? Most of them are glorified statuses. Mr. Foley, state what's going on with the case. Judge, I'm waiting for the state to give me a discovery. I still haven't received it. Once I received it, I'll be taking depositions. I'm asking for a continuance. Judge says no problem, gives you continuance 1 to 3 months. That's standard practice. Should you be at your court dates? It's a question that everybody asks. It depends. If I'm going to be at your court date, you should probably be at your court date so you can listen and find out what's going on. If I am not going to be at your court date and I'm filing a motion to continue, then you should not go because you're just wasting your day. Now, I say that sitting in a courtroom can help you. If you have a criminal case, I highly recommend that you go and sit in a courtroom. Especially if you know the name of your judge. Go sit in their courtroom and just watch. And if a judge was to say, sir, do you have a case? Well, I do have a case, Judge, but it's not today. I just wanted to observe the process, the criminal proceedings in your courtroom. Judge would go, no problem, right? You're free to access the courts and sit there. Don't talk about your case, but you are free to watch so you understand that process so you're not scared of it. So when my clients, I've never had a client do that, but I have clients that I said, look, I'm going to be in court. You should be in court. They watch, they listen. They may be there an hour or two, and my hearing may only be a minute about their case, but they get to see, and it kind of takes away the nervousness and the stress. I might have to pause this. Hang on, guys. All right, I'm gonna have to pause you.